The court actually found that this was not the case and that the lawyer did tell them to bring in the closing funds, but instead one of the buyers, instead of going to the bank, went home and took a nap. And I think there is a lesson right there as well that for key things like bringing in the closing funds, it's it's good practice to put that in writing to explain to the client to bring them in by what time and what date, and the consequences that if they don't bring in the funds on time, then the transaction might not close and they could be liable for not closing. And sometimes these things seem common sense, bring in the funds ahead of closing. And sometimes lawyers or clerks tell clients over the phone. But if you as a lawyer or your clerk sees that the client is not bringing in the funds, they're dragging their feet, it's probably a good idea to put that in writing just to be safe, to avoid these kind of invalid allegations or miscommunications. And in this case, the seller refused an extension, so the transaction simply did not close, and that's kind of what caused the litigation at hand.